Hi, I'm Ina Loring. I'm an attorney at Z Family Law, and I wish you happy holidays. Holidays are a time when we consider resolutions and evaluate our decisions and our plans for the coming year. So I'm here to talk about a decision that many people will be confronted with, specifically the decision to divorce, to dissolve a marriage. While divorce is never an easy process, it's often an opportunity to start a new life and to ring in a brand new stage for you and for your family. Being forearmed with knowledge about what divorce entails in Maryland can help make this process less scary and can help dictate your choices in terms of how you wish to proceed. Maryland recognizes fault-based divorce and no-fault divorce. Fault-based divorce effectively is where a party comes to court and says the other side broke the marriage, caused the dissolution of the union. No-fault divorce is what other states call irreconcilable differences, where regardless of whose fault it was that the marriage ended, the parties just seek a dissolution of the union and a resolution of the financial aspects of the marriage. There may be a myriad reasons why one would seek fault-based divorce over no-fault divorce, whether it's from wanting to have your day in court or if the fault plays into how assets were disposed of during the marriage or how a spouse believes they should be disposed of upon the dissolution of the union. One of these grounds is adultery, and to be frank, courts do not like to delve into evidence of adultery. They will not go through dirty laundry. They do not want to parse through multiple communications. The bar to prove adultery as a grounds for divorce is very high. One must prove disposition and opportunity to commit adultery. So sexting would not rise to that level, for example, or sending inappropriate pictures. Another grounds is desertion, where one spouse leaves the union. In that case, the wrong spouse must wait at least 12 months before seeking divorce on the grounds of desertion. Interestingly enough, case law has moved us forward into the 21st century and recognized that there are ways of deserting a marriage that don't necessarily involve slamming the door and leaving the house. There is a doctrine called constructive desertion, which is a basis for divorce, where one spouse makes it impossible for the other spouse to remain in the marriage while preserving his or her safety or dignity. So instead of punishing the spouse who leaves for committing an act of desertion, constructive desertion recognizes that sometimes you need to leave to protect yourself. Another grounds for divorce is conviction for a felony and misdemeanor, but the sentence must be for at least 3 years and at least 12 months of that term must be served before the other spouse can file for divorce. Another grounds for divorce, for fault-based divorce, is insanity. And while there have been times when we've all questioned our partner's sanity, insanity as a basis for divorce is a very, very high bar. One must show that the spouse claimed to be insane has been confined for at least 3 years due to their mental health, and there will need to be supporting testimony of at least 2 doctors to paint a picture to the court as to why the marriage cannot continue. Additionally, the party living, one of the parties must be in Maryland for at least 2 years before seeking divorce based upon insanity. So the usual requirement of you must be in Maryland for 6 months before you can seek divorce here doesn't apply. It's actually much longer for divorce based on insanity. One of the more frequently seen bases for divorce is cruelty and excessive viciousness. And one may question, well, is there a normal level of viciousness such that excessive viciousness is not allowed but normal viciousness is? These are old holdovers from old cases. Cruelty can entail a pattern of behavior, and much to the relief of a lot of attorneys, but also to the chagrin of a lot of people because it took until now to articulate it. There was recently a case that finally said cruelty doesn't need to be physical. It doesn't require bruises or physical injuries or violence. It can be psychological. It can be mental. It can be a pattern of behavior of belittling and diminishing and humiliating. And that would be a basis for divorce. Excessive viciousness usually does entail some form of physical violence, and you do not need both. So now, even a pattern of behavior that doesn't involve physical violence but involves mental violence can be recognized as a basis for fault divorce. Fault-based divorce is not the right fit for everyone. So there's also no-fault divorce, as I described. And no-fault divorce really falls into one of two categories. The spouses have been separated for 12 months before either one of them can file for divorce. And separated means living separately without coming back together as spouses and with the intention to separate. There is a case that involved two parties living together still, not being physically separated, but their lives were completely clearly demarcated. They effectively lived on different floors in different rooms. They lived as housemates. Naturally, that would be very hard to prove that effectively you have separation when you're living under the same roof. And that's very much the exception to the rule. So 12-month separation does require the parties to live separately. Another grounds, which is the most recent addition to the list of grounds for divorce, is mutual consent divorce, where regardless of whether the parties live together or not, regardless of whether they have minor children or not, they come to court after having entered into an agreement that spells out their rights, and certain points have to be touched upon in that agreement. If there are children, then custody and support need to be addressed. The issue of alimony or spousal support needs to be addressed. Disposition of retirement assets needs to be addressed, even if all it says is there are no assets or we waive alimony. Same goes for assets acquired during the marriage. And this is the easiest way to obtain a divorce. You work everything out through an agreement, you file a complaint, and the other party needs to file an answer. Up until the actual divorce hearing, both parties need to be on board with seeking divorce based upon mutual consent, and neither one of them should withdraw their complaint or their answer, because naturally, if a party does that, that vitiates the whole concept of both being on board that divorce is warranted. So these are the grounds for divorce in Maryland. There is no perfect fit, perfect scenario, perfect algorithm for any one family or any one couple, which is why it's always advisable to consult with an attorney who will be able to advise you not only what grounds are available to you, but which may be more justified and more reasonable to pursue given your short-term and long-term needs. We hope you have a happy and healthy New Year and a wonderful holiday season with your family. Happy holidays from Z Family Law.